There's a version of April 2nd, 2025 that ends differently. A version where a rain delay at a high school track meet in Frisco, Texas is just a rain delay. Where teenagers crowd under tents, wait out the storm, maybe grumble at each other a little, and then go back to competing when the weather clears. A version where two families drive home that evening not knowing how close they came to something unthinkable. Where Austin Metcalf graduates with his twin brother Hunter a few months later. Where Karmelo Anthony walks across his own stage at Centennial High and starts thinking about what comes next. That version existed right up until approximately 10 seconds before it didn't. 10 seconds. That is the number that this entire case, from the initial arrest through 14 months of legal proceedings to the jury verdict on June 9, 2026, ultimately comes down to. Not the 2 minutes of verbal back and forth that preceded it. Not the race of the people involved, not the crowdfunding campaigns, not the protests outside the courthouse, not the celebrity reactions on social media. The 10 seconds during which a physical confrontation escalated, a knife was drawn, and a single stab wound ended Austin Metcalf's life, and, in a very different but permanent way, ended Karmelo Anthony's freedom. What happened inside those 10 seconds is the most analyzed, most argued over, most emotionally charged 10 seconds in recent Texas criminal history. And now, with Anthony convicted of murder and sitting in state custody at the Wallace PAC unit in Navasota, Texas, beginning a 35-year sentence, those 10 seconds are being examined all over again, this time by appellate lawyers looking for the legal seam where something went wrong in the courtroom. This is the story of those 10 seconds. What they actually show, what both sides argued they meant. Why the self-defense claim that Anthony's legal team built their entire case around ultimately collapsed, and whether that collapse was as inevitable as the verdict made it look. If you are new to the verdict room, welcome. This channel follows the evidence all the way to the end and then delivers a real conclusion. Subscribe right now and hit the notification bell so you never miss a new investigation. Now let's go back to Frisco, Texas and look at what actually happened. April 2nd, 2025 was supposed to be a competition day, the regional high school track and field championship at David Kuykendall Stadium on the Memorial High School campus. A morning full of athletes, coaches, parents, and the particular energy that only spring sports events carry. The sense of something building toward a finish line. Then the weather changed. When a severe thunderstorm rolls across North Texas, it does not negotiate with athletic schedules. The rain came in hard and fast, and a weather delay was called. What that meant practically, in the moment, was that hundreds of young athletes suddenly had nowhere organized to be. They scattered for cover, filling the pop-up team tents that schools set up at the edges of the track. Those tents are not large. They are canopy structures, basic shelter, designed for team gear and shade, not for housing a dozen teenagers packed in side by side while a storm hammers the canvas overhead. Under Memorial High School's tent that morning, space was already tight. Memorial athletes were crowded in, some standing, some on the metal bleacher sections at the perimeter. Into that environment, Karmelo Anthony had moved. He was a student at Centennial High, a rival school, and by accounts from multiple witnesses, he had made his way to the memorial tent to get out of the rain. He sat down on the bleachers, backpack in his lap, waiting for the storm to pass. This is where the first dispute in the case begins, and it is worth pausing on it before we get to the 10 seconds, because it shapes the entire legal argument that followed. The prosecution's position, argued consistently from opening statements through closing arguments, was that Anthony made a choice to enter that specific tent. Not a neutral or accidental choice, a deliberate one. They pointed out that there were other covered areas available. His own school's team tent, other sections of the bleacher overhangs. The prosecution argued that sitting in a rival team's tent, refusing to leave when asked, and keeping his hands hidden inside his backpack throughout the exchange, was not the behavior of someone seeking innocent shelter from the rain. It was, they argued, the behavior of someone who had already made a calculation. The defense pushed back hard on that framing. Their position was that the stadium layout, combined with the sudden severity of the storm, limited Anthony's options significantly. That the picture the prosecution was painting, a calculating teenager selecting a specific tent as a trap, was a story built backward from a terrible outcome, not a conclusion the evidence actually supported. They argued Anthony was doing what anyone would do in a downpour, finding the nearest dry spot. Both of those arguments were made to a jury. The jury heard them and ultimately agreed with the prosecution's framing. But to understand why, you have to understand what happened after Anthony sat down. By testimony from multiple student witnesses, the exchange between Anthony and the memorial athletes lasted somewhere around 2 minutes. Austin Metcalf and his twin brother Hunter both approached Anthony. Austin was the primary speaker. Anthony was told to leave. According to witness accounts, he was asked to move somewhere between 10 and 15 times. He did not leave. He stayed seated. His hands remained inside or near the backpack throughout. At some point during those 2 minutes, Anthony reportedly said words to the effect of, "Touch me and see what happens." That phrase became one of the most discussed pieces of the entire trial. The prosecution argued it was a deliberate provocation, an invitation to physical contact from someone who already had a weapon ready. The defense argued it was the statement of someone feeling trapped and trying to establish a boundary, not an invitation, but a warning. Then the physical contact happened. This is where accounts began to diverge most sharply at trial, and where the self-defense analysis gets genuinely complicated. The prosecution's version: Austin Metcalf pushed Anthony, a relatively limited physical act that did not constitute the kind of threat that justifies drawing a weapon and using it on another person. In the prosecution's framing, Anthony responded to a shove with a knife, which was grotesquely disproportionate. The defense's version: a 215-pound varsity linebacker, someone physically conditioned by years of competitive football, forcefully put his hands on a 130-pound kid who was seated on metal bleachers with no clear avenue of retreat. That the physical differential was so extreme and the environment so closed that Anthony's fear response in that moment was genuine and legally significant. The size difference was real and documented. 80 to 85 pounds separated these two teenagers. That is not a minor detail. The defense made sure the jury could not forget it. But the jury ultimately returned to the same place the prosecution had planted its flag from the beginning. What Anthony said, and when he said it. This is where the 10 seconds become everything. After the physical contact, within a period that witnesses and the video evidence suggested lasted no more than 10 seconds, Anthony reached into his backpack, produced a folding knife, and stabbed Austin Metcalf once in the chest. Austin ran from the tent, grabbing at his chest. He lost consciousness. Athletic trainers performed chest compressions at the scene. He was pronounced dead at the hospital shortly after. 10 seconds from shove to stab. The prosecution spent significant time in trial explaining the physical mechanics of what those 10 seconds required. Reaching into a bag, finding the knife among other items, drawing it, opening the blade. A folding knife requires a deliberate action to deploy, gripping it, striking with it. The state argued that this sequence, all compressed into those 10 seconds, was not an involuntary reflex. It was not the kind of thing a body does without the mind's participation. Each step required a choice. Micro-decisions made one after another in a compressed window, but decisions nonetheless. The defense countered that 10 seconds in a moment of pure adrenaline, when someone your size has just put hands on you, is not the same as 10 seconds in a quiet room. That the human stress response collapses rational deliberation. That a person who is physically assaulted while cornered in a hostile environment is not making careful sequential choices. They are responding to signals their nervous system is sending faster than conscious thought can intercept. Both of these things are true in a physiological sense. And that tension between the law's requirement that deadly force be a reasoned, proportionate response to an imminent threat, and the reality that real human beings under real physical stress do not process the world in legal frameworks, is at the heart of why this case generated the debate it did. Texas self-defense law requires that a person claiming self-defense reasonably believed that deadly force was immediately necessary to protect against death or serious bodily injury. Every word in that standard matters. Reasonably believed, immediately necessary, death or serious bodily injury. The jury's job was to evaluate whether Karmelo Anthony, in those 10 seconds, met that standard. They deliberated for 3 hours and concluded he did not. Why? Because of what he said. Before the shove, before the 10 seconds, before the knife. Touch me and see what happens. That sentence, spoken while Anthony's hands were still in his backpack, while no physical contact had yet occurred, became the fulcrum on which the self-defense claim balanced, and ultimately tipped over. Because self-defense in Texas carries a significant limitation that the prosecution hammered throughout the trial. A person who provokes the situation that leads to the violence generally cannot then claim self-defense for their response to that violence. The legal term is provocation, and its presence in a self-defense scenario creates serious complications for the person claiming it. The prosecution's argument was not merely that Anthony used a knife when a shove did not justify one. Their argument was more precise and more damaging than that. Anthony issued a verbal challenge inviting physical contact, and then used that physical contact as the trigger for a deadly response he had already positioned himself to deliver. The weapon was in the bag before Austin Metcalf touched him. The warning was issued before Austin Metcalf touched him. The hands were inside the backpack near the knife before Austin Metcalf touched him. In the prosecution's framing, the 10 seconds were not a panicked reaction to something unexpected. They were the completion of a sequence Anthony had already set in motion. The defense tried to dismantle this at every step. Their cross-examinations of witnesses focused on inconsistencies between what students told investigators immediately after the incident and what they testified to on the stand. Some of those inconsistencies were real, and the defense was effective in highlighting them. They questioned whether the surveillance footage, grainy, shot from stadium light poles high above the action, washed out by the storm, actually showed what the prosecution claimed it showed. They established the physical size disparity clearly and returned to it repeatedly. They argued that the touch me and see what happens statement was a boundary, not a provocation, but they could not change what happened in the 10 seconds, and they could not change what Anthony said immediately after. When Officer Eduardo Cortez detained Anthony near the edge of the stadium and began communicating over his radio about the suspected perpetrator, Anthony spoke. He said on body camera audio that was played for the jury, "I'm not alleged. I did it." No crying, no explanation, no panicked recounting of being shoved first, of feeling cornered, of acting in fear, just a flat declarative acknowledgement stated without apparent distress to a police officer who was still managing the scene. The prosecution called it a confession delivered with no remorse. The defense reframed it as the statement of someone who believed he had acted justifiably and therefore had nothing to deny. They played additional audio in which Anthony told a coach, before he was cuffed, that the other person had put hands on him first. They argued the full picture showed a young man who was transparent, not cold, someone who wasn't hiding anything because he believed he had done what the situation required. The jury weighed both interpretations and returned a guilty verdict. On June 9, 2026, Karmelo Anthony was convicted of murder. The jury also rejected the sudden passion claim, a legal avenue in Texas that can reduce a murder conviction to a lesser charge when the defendant acted under an immediate provocation that any ordinary person might be overwhelmed by. The jury did not find that standard met either. They sentenced Anthony to 35 years in prison. The day after sentencing, he was transferred to the Texas Department of Criminal Justice and taken to the Wallace PAC unit in Navasota. He is 19 years old. He filed notice of appeal on June 10th. Now we are here. 14 months after the event itself, and this case is entering a new phase. Quieter, slower, more technical, but no less consequential for everyone involved. The appeal that Anthony's legal team has signaled will center significantly on what happened during jury selection. The defense raised a Batson challenge during the trial, a legal mechanism that allows attorneys to object when they believe jurors are being removed from a panel for racial reasons. The prosecution struck 3 black female jurors from the pool. The defense argued these women were similarly situated to a white female juror who was not removed. The prosecution offered a race-neutral explanation. The 3 women were teachers of school-aged children, which the prosecution said made them less suitable for this case. The white juror was also an educator, but in a non-traditional school setting. Judge John Roach sided with the prosecution at the time. The jury was seated with no black jurors, though several other jurors of color were included. The final composition was 11 women and 7 men, counting alternates. An appellate court will now review how that Batson challenge was handled. It will look at whether the trial court applied the correct legal standard, whether the race-neutral explanations were genuinely neutral, or whether they were pretextual, and whether the way the challenge was evaluated was consistent with what the law requires. This is a legitimate legal argument. Batson violations have led to reversals in serious cases in Texas and across the country. There are other grounds the appeal could raise: the jury instructions around sudden passion, evidentiary rulings during the trial, the sufficiency of the evidence to support the verdict given the self-defense claim. The specific arguments will crystallize once the formal briefs are filed, which could take months given the timeline of appellate proceedings in Texas. What is important to understand, and what gets lost in social media discussions every time an appeal is filed in a high-profile case, is what an appeal actually is and is not. An appellate court does not conduct a new trial. There is no jury. No witnesses take the stand again. No new evidence is introduced. An appellate court reviews the written record of what happened in the trial court and asks whether legal errors were made that affected the fairness of the proceedings. The question is not whether the jury reached the right conclusion on the facts. The question is whether the process by which they reached that conclusion followed the rules. If an appellate court finds a serious legal error, if they determine that the Batson challenge was handled incorrectly, for example, the most common outcome is not freedom for the defendant, it is a new trial. And a new trial means the entire process begins again: jury selection, opening statements, witness testimony, closing arguments, deliberation, verdict. A new jury could convict again. Under Texas law, a new jury is not bound by the 35-year sentence the first jury imposed. They can impose any sentence within the legal range for murder, which includes sentences more severe than what Anthony is currently serving. That is the real weight of the appellate gamble, and it is something Anthony's legal team is navigating carefully right now. Meanwhile, Anthony separately filed a pauper's oath shortly after the verdict, a formal request to the court for appointed appellate counsel on the basis that he cannot afford to pay for representation. This came as a surprise to observers who had tracked the fundraising campaign on his behalf, which by some counts reached over $600,000. The court will review the filing and make its own determination about whether the financial claim is supported. High-profile murder defenses are extraordinarily expensive. Expert witnesses alone can consume enormous sums. Investigators, forensic consultants, the official court record, legal fees across more than a year of active litigation. None of it is cheap, and there is no guarantee that what was raised in a crowdfunding campaign reflects what was actually available for legal costs. The court will sort through it. What is not in dispute is that Anthony's right to appellate representation is a constitutional one. If appointed counsel is granted, the appeal moves forward regardless of what happened with any fundraiser. Inside the Wallace PAC unit, life for Anthony is now governed entirely by TDCJ protocols. The intake process involves medical and mental health screening, security classification based on the nature of the offense and the length of the sentence, and evaluation for appropriate housing placement. For a 19-year-old entering the system on a murder conviction involving a deadly weapon, that classification process is not routine. His profile will be reviewed carefully before any permanent housing assignment is made. Phone calls are monitored. Mail goes through a digital scanning center. Visits are scheduled by the institution and subject to custody status and intake restrictions. For a family that was accustomed to being part of their son's daily life, watching him compete, celebrating his academic progress, preparing for his graduation, the adjustment to this level of mediated, monitored, limited contact is a particular kind of grief that does not come with a roadmap. Under Texas law, Anthony's 35-year sentence for murder involving a deadly weapon carries a specific parole restriction. He must serve one half of the sentence before becoming eligible for parole consideration. Half of 35 years is 17 and a half. Good conduct time, credits that inmates accumulate by following rules and participating in programs, does not accelerate the initial parole eligibility date for this category of offense in Texas. That means Anthony, who is 19 now, will not be eligible for parole review until he is approximately 36 or 37 years old. And parole eligibility is not parole. The Texas Board of Pardons and Paroles reviews the case, examines institutional behavior and program participation, hears input from victims' families and prosecutors, and makes a decision. In serious violent cases, first review denial is common. If denied, the wait for the next cycle begins. The full 35 years is a real possibility. The Metcalf family will have a voice in every one of those reviews. Austin's parents, who have carried themselves with remarkable dignity throughout this entire process, refusing to let extremist groups use their son's death as a banner for racial grievance, pushing back against the sensationalism that swirled around this case from the beginning, have made clear that they want accountability acknowledged at every stage. They will be present in that conversation. Austin Metcalf was 17 years old when he died. He was a twin. He was an athlete his school counted on. He had a future that everyone around him expected to see unfold. His brother Hunter accepted 2 diplomas at the graduation that followed. That image, one young man walking a stage alone when there should have been 2, is what lives at the permanent center of this story, regardless of what the appellate courts eventually decide. Karmelo Anthony was 17 years old when he made the decisions, in a 10-second window inside a rainstorm that ended Austin's life and began the dismantling of his own. He is now 19. He will spend at minimum the next 17+ years inside the Texas prison system before anyone officially asks whether he should be allowed to leave. What those 10 seconds cost, in full, is still being calculated. The self-defense claim did not simply fail because the jury was unsympathetic, or because the trial was unfair, or because the racial dynamics of the case contaminated the verdict. Those arguments will be litigated in the appellate process and deserve to be examined carefully. But the self-defense claim also did not fail randomly. It failed because of a specific sequence: a verbal challenge issued before any physical contact, hands kept concealed near a weapon throughout an escalating confrontation, and then a deadly response deployed faster than the law's standard allows unless the threat genuinely rose to the level of death or serious bodily injury. Whether a shove from a much larger person in a closed environment with no clear exit constitutes that level of threat. That was the question. The jury answered it one way. Anthony's appellate lawyers will argue the question was never fairly put to the jury in the first place. Both things can be true simultaneously. The verdict can be legally supported and still generate legitimate questions about fairness. The self-defense claim can have real merit as a legal argument and still have been insufficient to overcome the weight of what the prosecution established. This is what serious cases look like when you follow them past the headline and into the actual record. The next development in this case will come from the appellate courts. It could take a year. It could take longer. When it comes, the verdict room will be here to break it down fully. If this case has stayed with you, drop your analysis in the comments below. Do you think the self-defense claim had enough legal foundation to succeed? And if so, where do you think the defense failed to make it land? Do you think the Batson challenge gives the appeal real traction? And what do you make of the 10 seconds themselves? Is that window of time evidence of intent or evidence of fear? This is exactly the kind of conversation this community was built for. Subscribe to the Verdict Room if you are not already part of this. We do not do summaries. We do not do hot takes. We follow cases all the way through, from the first reports, through the trial, through the appeals, through whatever comes next. Hit the like button if this breakdown gave you something real to think about. New investigations drop every week. Evidence speaks. We deliver the verdict. There is one more dimension of this case that deserves direct attention because it has been present from the beginning, and it did not disappear after the verdict was read. The racial dimension. Austin Metcalf was white. Karmelo Anthony is black. In the America of 2025 and 2026, that combination, a black teenager charged with the killing of a white teenager, was always going to attract a certain kind of attention that had nothing to do with the specific facts of what happened under that tent. And it did. White nationalist organizations held a protest at the very stadium where Austin died, weeks after the stabbing. Extremist figures online adopted Anthony as a symbol of what they called systemic injustice against young black men. The families of both teenagers were caught in the middle of a political and cultural argument they never asked to be part of. Austin's father personally confronted the organizer of the white nationalist protest and asked him to stop using his son's image. That took something. That took a grieving father in an impossible position, choosing decency over the available comfort of having his anger channeled by people who had a use for it. The racial dimension did not stay outside the courthouse. It came inside with the Batson challenge during jury selection. The final panel included no black jurors. The prosecution struck 3 black female jurors, offering the explanation that they were teachers of school-aged children. The defense challenged that explanation and lost the challenge at the trial level. Whether that ruling was correct is now a live question in the appeal. People on both sides of this case have a legitimate interest in whether the jury composition affected the verdict. That is not a radical position. The Batson framework exists precisely because the Supreme Court recognized decades ago that jury composition can be manipulated through the exercise of peremptory strikes, and that this manipulation can happen in ways that are difficult to prove but real in their effect. The question an appellate court will ask is not whether the jury should have looked different, but whether the process by which it was assembled followed the rules. That question deserves a serious, careful answer. Not a political one, not a social media one. A legal one applied to the specific record of what happened in that Collin County courtroom during jury selection. The Metcalf family has maintained throughout that the trial was not about race, that Austin's death was not a racial crime, that the verdict reflected the evidence, not the demographics of the jury. Those are their conclusions to hold, and they deserve to be respected. They knew their son. They sat through every day of that trial. Their experience of this case is not something that commentary from the outside can override. But the legal system's obligation to ensure fair proceedings exists independent of any individual family's conclusions about fairness. The two things are not in conflict. A trial can be conducted with honest intent by everyone involved and still contain errors that an appellate court is required to correct. That possibility is built into the structure of the legal system on purpose, as a safeguard against the inevitable imperfections of human judgment under pressure. The community of Frisco, Texas has been living inside this case for 14 months. There are students at both Memorial and Centennial High who were at that track meet on April 2, 2025, who watched the aftermath unfold from the bleachers, who knew Austin Metcalf or Karmelo Anthony or both, who carry that Wednesday morning with them in ways that don't show up in trial transcripts or appellate filings. For those students, the verdict did not close anything. It just formalized what had already been true for over a year, that something happened at their track meet that does not have a clean ending. The coaches who were there, the parents who got that call, the athletic trainers who performed chest compressions on a teenager on a wet rubber track, the emergency responders who transported Austin to the hospital, the officer who detained Anthony and had his body camera rolling when Anthony said what he said. All of those people carry this case in a way that is different from everyone who has followed it from the outside, and their experience does not resolve into the neat categories that online discourse tends to demand. Accountability and tragedy can coexist. A verdict can be legally correct and still be grieved. A young man can be held responsible for something terrible, and that responsibility can still not feel like enough for anyone. The Metcalf family does not get Austin back. The Anthony family does not get their son back, not for decades. The students who witnessed the violence do not get to unknow what they saw. What the legal system can offer in a situation like this is a process, a set of rules, imperfect but carefully constructed over time, designed to evaluate evidence and reach conclusions that can be defended with reference to something more than emotion or politics. The process ran its course in Collin County. It produced a verdict. That verdict is now being tested through the mechanism the system provides for exactly this purpose, the appellate process. However that process resolves, the 10 seconds at the center of this case will remain 10 seconds. They will always have happened. The knife will always have been drawn. Austin Metcalf will always have been 17 when he died. Karmelo Anthony will serve those facts alongside everything else he carries into the next 17+ years. If this analysis changed how you see the case, or reinforced what you already believed, tell us in the comments. This community has some of the most thoughtful discussions of any true crime channel on this platform, and this case deserves exactly that. What is your read on the appeal? Do you think the Batson challenge gives Anthony a real shot at a new trial? And if there is a new trial, do you think the outcome changes? Subscribe to The Verdict Room if you are not already here. Every week we go deeper than the headline. We follow the evidence, we respect the victims, and we deliver a real verdict. Hit the like button if this investigation gave you something to think about. We will be with this case every step of the way. Evidence speaks. We deliver the verdict.